Well, good afternoon, everyone. This is the House Judiciary Non-Civil Committee meeting. I appreciate everybody being here. Members, thank you for your attendance. My sense is we'll have a few more trickle in. We adjourned just about 10-15 minutes ago. Before we begin, let me introduce our Judge of the Week, Judge Billy Boyette. Judge, where are you? Judge, thank you for being here. We appreciate your being here and more importantly, being a resource for the committee. So we may spontaneously question you if need be in order to make our way. Thank you. All right, let's get going. We have several bills on the agenda. What I thought we'd do is just pick up where we left off with a couple of bills that we carried over from our last full committee. Let me ask Representative Efstration if he would come forward. He's got House Bill 770. Give us 1 second. And we've got a couple of subs in the folder. Can you just make sure we're clear on what substitute we're working from?
Yes, sir. It's LC 410192S.
0192S. Does every member have a copy of that? Does anybody not have a copy of that? Okay. Okay. Maybe just in the interest of time, if you could just walk us through where we were and then what changes were made and why, and then we'll do our best to answer any questions from members on the changes, and then we'll get to a motion.
Yes, sir. Thank you, Mr. Chairman. This bill initially created a new criminal offense of home invasion, as we previously discussed before the subcommittee and the entire committee, in an agreement to address concerns about the varying degrees of offense. We created home invasion first degree. The offender enters an occupied home while armed for the purpose of committing a forcible felony, and home invasion second degree when the offender meets all the other elements but enters for the purpose of committing a forcible misdemeanor, with differing restrictions as to punishment. Mr. Chairman, with some of the concerns that committee members expressed previously, as well as Legislative Council's request that we discussed at the previous committee hearing, Legislative Council's request was removed as far as the sentencing guidelines. Additionally, the bill initially had on lines 15 and 19 enters or remains within. The or remains within was removed to address that, and I do think that that is a beneficial change for the bill, addressing some of the hypotheticals that committee members raised previously. Certainly the objective is met with what's outlined here to, number one, identify the most serious of offenses which aren't currently isolated under existing burglary law. Number two, to ensure that there's adequate and consistent punishment for individuals that, as we mentioned, offenders entering to commit a misdemeanor theft can be charged with burglary, but not to commit a misdemeanor violent offense under existing law, and this fixes that issue and is completely consistent with the criminal justice reform that we've seen. The District Attorney of Gwinnett County, Danny Porter, is present and prepared to testify, having served on that commission. Additionally, Mr. Chairman, Alice Johnson, who is a representative with the Atlanta Police Department, is present. She testified at the subcommittee hearing and would be prepared to testify in favor of the bill. I am ready to answer any questions if the committee members have any, and would request favorable report.
The other change was, I think it was on line 26 of the substitute, where we went with the period at the word withheld as opposed to the subsequent language that was in the previous sub. Is that right?
That's correct. Thank you, sir.
All right.
Yeah.
Okay. Questions for the author? Mr. Strickland.
Representative, I agree with the change. I think it covers the scenario that I think it was Representative Hightower brought up at the last hearing. One question, though, the situation you gave us, scenario you gave us, where someone actually enters a home that's not occupied yet and waits for someone to arrive home to commit a crime, they would not be covered with this draft here, would they?
That's correct.
Okay.
The elements include entering an occupied home.
Okay. All right. Thank you.
Additional questions for the author? Seeing none, what's the pleasure of the committee? Mr. Gravely moves due pass. Is there a second? Second by Ms. Ballinger by substitute of House Bill 770 LC 410192S. Are there any amendments? Seeing none, any further discussion on the gentleman's motion? All signify. Mr. Hightower.
I hesitated because I thought Representative Atwood was going to be here and he had brought up a question. My only, and I mentioned this to you before. I thought Atwood was going to be here to bring this up, but the way you have it now, a mere possession of any weapon would hold them liable to this, correct? Or have them guilty of this?
Well, yes, sir, with the intent to commit a violent offense.
Okay, but not necessarily using that weapon for that. So, again, the example I gave you earlier, you got two guys dating the same girl, and they're in college, and you got one guy who says, he's getting mad because he's not getting the better end of the deal. He's carried around a pocket knife in his back pocket for who knows how many years. He goes into the other guy's house knowing he's going in there to punch this other dude in the face. Punches the guy in the face because he's dating his girlfriend, but he's got a knife in his pocket. Never intended to use it, never took it out. But because he was in possession of that, he would possibly be facing life to 10 years.
We would be in the second degree range at that point, which would allow greater discretion to ensure that, first of all, the sentence could be probated.
Well, what if he went in and it wasn't a misdemeanor, it was a felony? What if he punched the guy and disfigured him? His one punch knocked his teeth out or disfigured his face. Then it would be a felony.
Exactly. Entering for the purpose of committing a forcible felony while armed would fit under the statute. And Representative, I would argue this is consistent with mandatory minimums already codified for other offenses where maybe, for instance, in armed robbery, the taking is for a misdemeanor amount. It does not matter. The presentation of what appears to be a weapon in order to complete that crime would cause a sentence range completely consistent with this offense here. And sir, I would argue that entering into somebody's home while occupied, while armed, to commit a violent offense should be covered under Georgia law in a way that it isn't right now.
Are you concerned at all with the scenario that I gave you?
I believe that, and Mr. Poore can maybe speak to this, but prosecutors that are working in those kinds of situations would have a burden to prove to a jury beyond a reasonable doubt that the person entered for the purpose of committing a violent offense. And I would submit that would be we have prosecutors and juries that would be examining specific facts and maybe those circumstances and could make those determinations. I don't know if Mr. Porter has anything.
Mr. Hightower, I guess, first of all, I come from a mostly urban circuit, so I think in the scenario that you give rise to, I can't imagine that it would be charged under those circumstances, particularly if the knife stayed in the pocket. I mean, a lot of people carry pocket knives. If the knife was not an integral part of the offense, then I just don't see that as a reasonable scenario in a charging decision. I mean, I acknowledge that it's possible, but I think the nature of the offense, the analogy that we used was entering auto, stealing a car, hijacking a car, and in this case we've got criminal trespass, burglary as it's now written, home invasion. And I think when a reasonable person, including a juror, looks at home invasion, there's going to have to be some use of that offensive weapon
See,
to facilitate the felony.
And Representative, I apologize. I mean, you and I talked about this several times before this, and I really didn't think I was going to be the one to bring it up. Wood said he was going to, so I apologize. I'm the one bringing it up again. I was going to leave it up to him. Well, I just told you I told the representative I wasn't going to be the one to bring this issue up, but Atwood said he was. Now I apologize for me being the one doing what I told you I wasn't going to do. But I did give you this example, and what you're saying really drives my point kind of home, in my opinion, because this bill doesn't say that. If the bill said that he used the weapon, then it would resolve my issue. But this doesn't say that. But what you just said, well, if he didn't use the weapon, I doubt they'd charge this. But the way it's written now, it's just possession of the weapon.
Well, Representative, and I did have a chance to meet with Representative Atwood before the meeting here today and discuss it, and we are still in discussion about this. I don't want to speak for him, but I don't think he had taken an affirmative position yet on the bill. I will say this: when the perpetrator enters the home while armed, what can take place after that point is very unpredictable.
Right.
A burden of, in addition to showing that the perpetrator entered for the purpose of committing a violent offense, that the perpetrator intended to use the weapon, I believe we would have a more extreme burden than maybe we truly want, because things can be so unpredictable at that point. The homeowner can use violence in defense of the home and people in the home. The perpetrator might not enter for the purpose of using the weapon, but then decide to use it later. There are many other extreme circumstances that can take place, and by taking that step of entering a home while armed for the purpose of committing a violent offense, misdemeanor or felony is delineated here. I would submit the sentencing provisions are appropriate even under those types of circumstances.
And the only reason I draw this out sometimes in committee now and when we did it in subcommittee is because we're looking at such grave sentencing. I mean, it's life to 20 years, and I just want to make sure that if we're talking about creating a new felony, which that's what we're doing, with a sentence structure that's set up this way, just make real sure we're doing exactly what we wanted to do, and we're not catching people accidentally. That's all. That's just my only concern.
Well, and I would just finally say that with the 2 tiers, discretion is certainly permitted for the court to probate any sentence in those extreme circumstances where we feel like where it's necessary for the trial court to take that step.
And if I could add, Representative Hightower, the analogy or the thought that I would have is, at some point we have to make a decision about public safety, and and we do the same thing in convicted felon in possession of a firearm. There are those charges that range from the broke guy who pawns the firearm after having been convicted of a felony versus the person who might use that firearm in an armed robbery. And so the fact scenario, but this legislature has made a decision that as a public policy, you can't tolerate firearms in the possession of felons. And I think the same analogy applies here, is that you can't tolerate an unlawful entry into an occupied dwelling by an armed perpetrator. That's really what I think this is aimed at.
Thank you. Thank you for your explanation.
Mr. Coomer.
Thank you, Mr. Chairman. I'm sorry I missed the very beginning of the discussion. And this, I want to start off kind of asking along the same lines, but is weapon, have we defined weapon anywhere in the bill? Or, I mean, it's not in the bill, but does the article or the relevant code sections around this article define weapon?
No, sir. We briefly discussed this before at the prior committee hearing, and maybe I wasn't as clear. The intent was to keep this very broad because of certainly some cases we've seen where objects that where objects have been used as weapons, but to also rather than adopt the aggravated assault language of object, instrumentality, device, just being so broad to use weapon. That was in the original. I had very broad language in what I initially submitted to Legislative Council, and it was returned this way. And I actually prefer this. I think that weapon as used here, remains broad, would be an element, of course, for a jury for a prosecutor to prove and for a jury to find, while at the same time avoiding incredibly broad language where, say, a can opener could be asserted to, be a weapon. I think that's the basis with which this language was used.
So, but aren't there some code sections that do define weapons or dangerous weapons in other parts of the code?
Yes, I aggravated assault comes to mind.
So, so is there a reason that you wouldn't want to use the definition of a dangerous weapon or dangerous instrumentality that's already been established?
There again, I would have to actually defer to legislative counsel because different language was used in what was initially submitted, and this was the determination that was made. Actually used deadly weapon initially, and as I recall, or an object that, when used offensively, can cause serious bodily harm, and this language was chosen.
Okay.
I don't really have a further explanation.
Okay. What about have you defined? Is firearm defined in Chapter 7 of Title 16?
The no, it is not. But this tracks, as I recall, armed robbery, the armed robbery statute, where similar terms are not, definitions are not codified.
Okay. And I guess I will maybe like to hear from Ms. Travis about that if she wants to help me out with that. Those definitions, I was asking about the definition of weapon or dangerous weapon. Why would we use the broader, less definite language of just weapon?
Yeah, I think those are excellent questions. I'm not the drafter.
Okay.
So I don't know why that was chosen. I actually raised that with author as well.
Okay. All right. So the lesson for everybody is that you should draft bills that come to this committee.
I can answer the question better if I've drafted it.
I understand. I'm kidding about that. Last question really relates to lines 29 through 31 in the sentencing. You've directed that a sentence imposed under this article, or under this code section, would be imposed separately from and consecutive to any sentence for any other offense related to the act or acts establishing the offense under this code section. Why do you have that?
It's no merger of offenses.
I mean, I know what that does, but I'm
Yes,
asking
sir.
you, what's the policy for it?
Similar to hijacking motor vehicle, where the policy reason is that the sentence should be consecutive to, the offense should be distinct from, and a sentence, I would submit, consecutive to whatever else takes place, the forcible felony that's actually committed. This is a distinct offense, not to simply be merged with the ensuing crimes that would take place.
But and under, I think most criminal jurisprudence in Georgia, I mean, judges have the discretion to either have a sentence run concurrently or to stack them consecutively, as it is. So why are you saying the judges should not have that discretion in this particular instance?
Consistent with similar laws, as was mentioned, hijacking motor vehicle, possession of a firearm during the commission of a felony, all offenses already codified that have no merger provisions.
Okay, thank you very much.
Ms. Dickerson.
Representative Hightower answered the question for me, and it was about
Okay.
the mandatory sentencing. I was just still kind of a little bit leery about that.
Yes, ma'am.
Thank you.
Here's our posture. We have a move do pass by substitute of LC 410192S, and we do have a second. I'm going to ask again, are there any amendments? Mr. Coomer.
Thank you, Mr. Chairman. I'd offer one amendment would be to strike lines 29 through 31.
Mr. Coomer offers an amendment striking lines 29 through 31, obviously renumbering accordingly. Any discussion on the amendment? Any discussion on the amendment? Mr. Strickland.
This is just more of a question. If we strike that language, are we concerned that it's automatically going to make this offense merge, or are we just trying to give discretion to a judge by striking this language? I just want to make sure we're not creating an automatic merger in a sense.
My opinion is that a merger of offenses merger of sentences would occur as a result. I think it's important to be in place in order to have in order to make the offense meaningful. And I don't know if Mr. Porter has any other comments about.
I stated at the earlier hearing, in my opinion, that removal of that language would mean they would merge the verdict and a sentencing.
Well, if they have,
A judge would have the same discretion. I don't even think a judge could just sentence consecutively if that language was removed, because the convictions would merge because of the element.
so the elements would be, so there's the same elements for some underlying offense. Is that
Depending on the
so? Is it a rule of lenity issue? Is that what you're getting at, or
depending on the offense charged as the underlying offense?
okay?
Could be.
If I may, Representative Coomer, I wonder if we could take the shall and make it a may, if that would be a compromise in the two positions on line 29.
I think that would work. Yeah.
Does the gentleman want to amend his amendment?
Yeah.
Let's,
I'll amend
have
it
again.
to on line 29 to strike the word shall and replace it with the word may.
Mr. Coomer moves to amend by striking the word shall on line 29 and inserting the word may. Any further discussion on the amendment? Seeing none, all in favor of the gentleman's amendment signify by raising your hand. Darshan, I can't. Oh, there you go. Opposed? The amendment is adopted. Are there any further amendments? Mr. Coomer.
Feeling lucky after that one. I would move for an amendment to strike the words "or any other weapon"
Where are you?
beginning line 15. That would be in line 15, line 19. That may be the only two places.
Okay. Mr. Coomer moves to amend House Bill 770 by striking the words "or any other weapon" both on lines 15 and line 19. Any discussion on the amendment? Mr. Pack.
One concern I have, I'm not worried about that not being defined, because I think common sense, there's enough case law to say, what is another weapon. I feel like if we strike that, only people possessing guns will be covered, and I think that's too narrow. I could imagine a situation, you take a baseball bat, bash the door in, or a hammer even. I mean, that certainly should be covered. That's home invasion. So I would prefer to just leave that language in there, just because make it broad. And if it's vague or subject to a constitutional challenge, it's something that the defense could bring up. But I envision, as I read this bill, if it becomes law, that the usage is going to be for the most egregious cases where home invasion is a very serious crime, and that's I believe in many of our jurisdictions that crime is usually reserved for very violent offenders. And so I would prefer to have that language in there versus striking it, which will, I think, shrink the scope of the bill too much.
Any further discussion on the amendment?
Just, Mr. Pack, in trying to figure out the best language to use then, would you, if the amendment were to say, or any dangerous weapon, any other dangerous weapon, which I believe, Ms. Travis, don't we have dangerous weapon? Isn't that defined somewhere in code?
It is defined in 1611-127.1 for schools. Oh no, weapon is defined that way. I think dangerous. We have dangerous weapon in 1611, which I believe has to do with explosives. Yeah, that kind of stuff.
Shotguns and machine guns.
What's the one that includes like brass knuckles and all those?
That's the securing a weapon on a school ground.
Okay.
Mr. Chairman, may I? Thank you, sir. I've just been given the definition provided under aggravated assault. This is 16-5-21.2. It's commissioned with a deadly weapon or with any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in serious bodily injury. I do know, in fact, deadly weapon is defined elsewhere in the code section, and there's existing case law and firearms included in that. And I would have no objection to substitution of that language for the existing language here.
Mr. Chairman, I will withdraw my my proposed amendment and make a motion for an amendment to include what he just read on lines 15 and 19.
Let me ask Mr. Evstration to go ahead and read that back.
Yes, sir.
And the strike and the insert.
It's a deadly weapon or any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in serious bodily injury.
And that would occur on lines 15 and on line 19?
Yes, sir.
Okay. And you'll reference that for counsel so that she can have that in the sub?
Yes.
What is the that section? Does it say definition of?
No, sir. It is. This is different instances in which aggravated assault may be charged, and that is one of the instances involving that object or weapon.
Can I ask a question?
Sure.
Is that insertion become, is that in lieu of firearm or any other weapon, or is it supposed to come after firearm? Does it
In-
be firearm or
In lieu of was.
okay.
Yes. I think firearm is supposed to stay.
Okay.
Mr. Coomer, is that your intent?
Yes.
Okay. Is that clear? Ms. Travis, is that clear?
Yes, sir.
Okay. Any other questions or clarifications regarding the Coomer amendment? All in favor of the gentleman's motion? All in favor of the gentleman's amendment signify by raising your hand. Opposed? The amendment is adopted. Are there any further amendments? Are there any further amendments? Seeing none, we have a move of due pass, we'll say by substitute, of HB 770 LC 410192S. All in favor of the motion signify by saying aye. Opposed? Let the record reflect one opposed. Three, I'm sorry. Let's do this. All in favor of the gentleman's motion signify by raising your hand. Opposed? And the motion is adopted. Thank you, Mr. Evstration.
Thank you, sir.
Make sure you fill out your form at rules.
Yes, sir. All right.
Okay.
Thank you, Mr. Committee.
Let's call HB 804, which is also a carryover. Mr. Lindsay. And Mr. Lindsay, let me ask you as well, since this is a carryover from last time.
Yep.
I think if you could do your best to summarize as expeditiously as possible just what the what the question areas were, then the changes. You can go ahead and highlight where they are in the new sub. Let's make sure we have the right sub.
The sub you should have in front of you is LC 295901.
Hold on one second. Oh, okay. Have you? Does every member of the committee have that sub LC 295901 ERS? I think everybody's got it.
Yes.
Is that correct? 5901 ERS?
Yes, sir.
Okay.
Got it?
Ms. Kendrick, do you have it? Okay. Mr. Lindsay.
Thank you, Mr. Chairman. The committee asked several questions, and let me sort of walk through the questions and how we have tightened up the language. First off, there was a question as to what term of art we should use in terms of the child's mental state. And speaking with psychologists and looking at other states, we believe that the language that would best express what needs to be done here is psychological or emotional distress, and that's the language that we have used here. There was also a question as to whether or not that psychological or emotional distress should be tied to the child's ability to testify. And in looking at other states as well, quite frankly, as I talked to a child psychologist who said if the child suffers from serious psychological emotional distress, it's going to impair the child's ability to testify. So in the abundance of caution, given the rulings in other states, we do believe that it's appropriate to have in there tighter language which simply says serious psychological or emotional distress which impairs such child's ability to communicate as a result of testifying in the presence of the accused. That's language that's tracked from the present statute as well. It's also language we've seen in other states, and like I said, in talking to one child psychologist that I spoke with, if you have that type of extreme emotional distress, you're going to be impaired from the ability to testify anyway. So it's, I think, from an abundance of caution, given the right to cross-examine, that probably is a good thing to put in there. We also tightened up the language that you'll see in lines 28 through 30 to make it clear that what the court must find is exactly that by testifying live that the child is going to suffer from what I've just outlined, and then the court may use any one or more of the following factors in determining that, but still they must determine that specific item. Also tightened up the language regarding what the court must find, and in terms of procedure, which is found on lines 68 through lines 67 through 80, in terms of the factors that the court must look, not factors, but what the court must outline in terms of how the examination is to be conducted. That's essentially it, Mr. Chairman.
Mr. Atwood had a concern or two, I think, that may have been cleaned up with regard to opposing counsel. Was there language that was formally in there that may have been a bit limiting?
We excluded that particular language.
Okay.
It's not specifically addressed in terms of who's excluded, who's not excluded, but it does sort of outline the procedures that need to be taken if the committee wishes to put in there expressly some language regarding if one side is to be excluded, both sides need to. I've got language if you feel like it's necessary. In addition to that, the Cherokee County solicitor sent me, Jessica Moss, sent me some additional criminal code sections that she would like for the court, rather for the committee to consider. And Representative Ballinger has those. She believed that based on her experience, 4 additional offenses ought to be included, and I have them here. It would, if you wish to add them, they're not in this because I got them about an hour and a half ago. They would be at lines 19 if you wish to include them, and that would be 16.520, 16.523.1, 16.590, and 16.595. And that's basically dealing with assault, battery, stalking, and aggravated stalking. She said that a lot of the times minors are forced or required to testify in those situations as well, and this bill would be helpful in those situations.
Can we expect that in the nature of an amendment coming up? All right.
Representative Ballinger, I think we'll be offering that as an amendment.
Okay.
I just want to go ahead and alert.
Yeah, no, appreciate it. Questions for the author on the changes? Mr. Pack.
Representative Lindsay, where I know you said that it's not expressly provided, but the provision where I guess the defense attorney can be present during the questioning, where would that be kind of encapsulated?
What we have in there is simply just that gives the court the discretion to determine, let's see, lines 71 and 71 through 73 list the individuals or categories of individuals allowed to be in the presence of such child during such testimony, etc., etc. That's where we have it in there. Simply giving the court the discretion on who is and who is not to be allowed. In some situations, it may very well be in the court's discretion that both lawyers need to be excluded, and we'll simply examine the child because of the tender years out by Skype or whatever else method. In some situations, the court may determine that both of the lawyers can be in there. Or we left it to the discretion of the judge. I would certainly expect that if one side's out, both sides are out.
Just to clarify, what is the precedent on that? What's the state of the law in terms of? I mean, there's got to be some uniform.
Yeah.
That's not new, so maybe we could just get some
No, it's not new.
clarification.
In some of these statutes, this is John Caldwell, who's a senior assistant in my office. He is one of the people who tried this case originally.
Mm-hmm.
In many of the states, the rule that they set up is that if the prosecutor makes the request to be present
Mm-hmm.
in the room with the child, then the defense attorney has to be present as well. So if the judge limits the prosecutor to only in court presence, not in the same room, the defense attorney would have the same right.
I just want to make sure we're all clear about that.
Yeah.
Great. Mr. Coomer.
Thank you. Mr. Lindsay, just the last time we talked about this bill, we heard some from the defense bar who raised the concern that this code section would expand protections from child victims to also child witnesses.
Yes.
Can you give us a response to that, or have somebody address that concern?
I believe we can. We've done some extensive research on that. We believe that we're well within the law on that, and perhaps
Yes,
Caldwell would be the best one to do that.
yes, sir. So we've researched it. Currently, out of the states that allow child remote testimony, 33 states allow the child witness in addition to the child victim. So Georgia would now be in the majority instead of the minority by allowing child witnesses to testify in addition to child victims.
And let me add that in many situations, what we're dealing with are cases in which the violence has occurred in a domestic setting, and so oftentimes a child is one of the witnesses to the violence, either to another child in the home or to another parent, and so the same trauma would be taking place. And keep in mind, we are tightening the language here to make it very expressly clear that we're talking about severe psychological trauma, which will impair the child's ability to testify.
Okay, thank you for that. I had one other question, and kind of following up on the discussion before. The other significant change this makes is expanding the protections from a child who is 10 years old to a child who is 18 years old.
Yes.
And I was wondering if you could respond to that concern as well.
Well, that's the whole purpose of the bill, is to bring us in line with many other states and to recognize that that children under the age of 18 years old may be suffering, may be particularly traumatized by testifying, and which may limit their ability to be examined or cross-examined truthfully. We're simply trying to bring us in line with reality. 10 years old is way too young. 18 years old we believe to be a more appropriate age. Keep in mind that the judge we're giving the judge wide discretion as to how they're going to conduct that examination. So certainly a child who's perhaps 17 years old, there's going to be, let me give you an example. Both lawyers are going to be allowed to be present. Perhaps for an 11-year-old, that's not going to take place. That's why we're giving the court such wide latitude, and we're not trying to prescribe one size fits all in case of remote testimony, but giving the judge that kind of sliding scale discretion.
Just to follow on with Mr. Caldwell again, since you seem to have the statistics over there, you know how many states have an 18-year-old cutoff as opposed to something under 18, say 16 or 14?
Yes, I have a chart here. I can actually look through it for you. The majority of the states seem to be under 15 16 or 15. However, we do have at least 1, 2, 3. For 4 states are under 18, but I would say the majority is under 16 or under 15. But as far as the challenges go for those states that have the under 18 provision, they've all been upheld.
Okay.
It's simply, like I said, given the fact that we're giving wide discretion to the judge on that sliding scale, that's why I felt it was appropriate to go up to 18.
Would you be opposed to an amendment to change it to 16?
I would be opposed, but I appreciate the wisdom of the committee, but I believe 18 is more appropriate.
Thank you.
Any further questions for the author? Seeing none, what's the pleasure of the committee? Mr. Ballinger? What's that? We had testimony at the first full committee on this previously, so we're going to, since it's a carryover, we're just going to go ahead and talk to the changes and take a motion. Ms. Ballinger.
Chairman, I'd like to make a motion, please, to add 15.520, 15.520.
Why are you moving due pass?
I'm sorry.
Are you moving due pass first?
Yes.
Mr. Pack is moving due pass by committee substitute for HB 804 LC 295901 ERS. Ms. Ballinger is seconding that amendment. Are there any amendments, Ms. Ballinger?
Yes, there is. I would like to add on line 19, 16.520, 16.523, 16.590, and 16.595, which would include assault, battery, stalking, and aggravated stalking.
Actually,
to the
16.523.1.
Let's
25.
Can we just slow down a little bit?
Okay, sorry.
Thank you. Because we don't have that amendment printed, is that correct?
Okay, no, we don't.
All right, go ahead. Maybe just say
It's
those a little slower.
16.520,
Mm-hmm.
16.523.1, 16.590, 16.595. The first one being simple assault, the second one being battery, the third one being stalking, and 16.595 being aggravated stalking.
And I apologize, it should be also 16.523 and 16.523.1. My apologies.
So it's 16.520, 16-5-23,
16.523.1, 16.5-90, 16.5-95.
Okay. Let me ask counsel if she got all that.
I do. I'd like to put them in where.
Yes, ma'am. Yes, ma'am. Any discussion on the amendment? Is sure. Any discussion on the amendment proposed by Ms. Ballinger? Is there any objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments? Seeing none, any further discussion? Mr. Coomer.
I did have an amendment
Okay.
to offer. I would, on line 14, strike the number 18 and insert the number 16, so it would read that the statute would apply to, or that the child would be defined as a person who's under 16 years of age.
Okay. Is that clear to all members of the committee? Mr. Coomer proposes in amendment line 14 to strike the number 18 and insert the number 16. All in favor of the gentleman's amendment signify by raising your hand. I can't see Darshan. Opposed? And the amendment fails. Are there any further amendments? Seeing none, we have a motion of due pass by substitute of HB 804 LC 295901 ERS, again by substitute. All in favor of the motion signify by raising your hand. Opposed? The motion is adopted. Thank you, Mr. Lindsay.
Thank you, Mr. Chairman. And thank you to the committee.
Thank you all.
Let's go to House Bill 911, Ms. Ballinger. Ms. Ballinger, you can do it. You can present from there if you'd like.
Yes, sir, Mr. Chairman. Bring before you, basically it's an addition. It's currently enshrined in case law, but we're codifying it, adding, as used in this code section, the term strangulation means impeding the normal breathing or circulation of blood of another person by applying pressure to the throat or neck of such person or by obstructing the nose and mouth of such person with any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in strangulation. I'll be happy to take any questions.
Questions for the author? Or for Mr. Speha, since he's assumed the position, so to speak. What's that? All right. I see no questions. We've got a couple people signed up to speak. Couple people signed up to speak on this. Holly Comer-Tuckman with the YWCA of Northwest Georgia. And let me ask you, just in the interest of time, we've got a full agenda, Holly. If you could limit your comments to a few minutes, we'd appreciate it.
Yes, sir, Mr. Chairman.
Thank you.
I am Holly Comer-Tuckman, and I'm the CEO and Executive Director of the YWCA of Northwest Georgia, and I also serve on the Georgia Commission on Family Violence. And so I'm here to share a few statistics and to put a face to why this bill is important. Over 44% of domestic violence victims that we surveyed recently in our domestic violence programs have been strangled. Victims of prior attempt of strangulation assault are 8 times more likely to be murdered. We believe that this bill can help save lives. 37 other states have already enacted legislation codifying strangulation assault as a felony offense, including Alabama, North Carolina, Tennessee, and Florida. But more importantly, I'm here to talk for people who cannot be here to speak to you today. And one of those is Donna. She was a mother, a wife, an ex-wife, a sister, and a daughter, and a mother of 2 boys. She was murdered the Christmas before last. And when we reviewed the temporary protective order that was in place, she had been strangled. Attempted strangulation by her ex-husband who murdered her. So she unfortunately became one of these statistics. And we firmly believe that if we pass this legislation and make this the offense that it should be, because it is very dangerous, it only takes about 4 pounds of pressure for less than 10 seconds to cause permanent damage. So we also had another client who now has grand mal seizures because she's had strangulation assault so many times. So I ask you all to pass this piece of legislation, and I thank you for your time.
Ms. Tuckman, thank you for taking the time to come down here, and we appreciate your commitment on the issue. I see no questions. Is Lieutenant Janet Brady with the Atlanta Police here? There you are, sorry. Lieutenant Brady, welcome.
Thank you, Mr. Chairman. I'd also like to thank Representative Ballinger for introducing this legislation. I'm just here to speak for the Atlanta Police Department, Chief Turner, in support of this this bill. As police officers, we no longer use the carotid artery restraint to subdue suspects, and the reason for that is because it is lethal. And I think that if we as a police department and we as police departments across the nation no longer use this restraint, then I think that's an important point to point out, that it is lethal and it does cause serious injury. I think I wanted to point out also that this this legislation will give officers in the field the tool to make the appropriate charge when it is necessary, when a strangulation has occurred. And I believe that I just also wanted to point out that even though when an officer does make this charge, they will have to have probable cause to make the charge. So there will have to be, we'll have to look at the totality of the circumstances, the witnesses, things that the victims say. So it won't be just an automatic charge, but it will give us a tool to make the appropriate charge when necessary.
Thank you, Lieutenant Brady. I see no questions. And thank you for what you do.
Thank you.
We appreciate it very much. Is Frank Rotundo here? No? Okay. C.R. Chisholm, with the Georgia Association of Solicitors General.
Right here.
Mr. Chisholm?
Yes, sir. Thank you, Mr. Chairman. C.R. Chisholm, Solicitor General, Athens Park County, President of the Georgia Association of Solicitors General. Just here to say we support the bill. Ask you to pass it. Thank
Perfect. Well said. There were some others who could see that kind of presentation. Perfect. Thank you for being here, and thank you for what you do. All right, I see no other witnesses signed up. What's the pleasure of the committee, Mr. Coomer?
Just a question, either for the author or perhaps for the lieutenant. I frankly had never heard of that particular restraint move that you were describing before just now. I'm wondering, are there other justifiable or legitimate instances in which a person would engage in what we're defining as strangulation, such that there should be exceptions written into the code that we're about to pass, and maybe specifically for law enforcement? Are there agencies? Are we aware of any agencies that still use this particular method of restraint? Okay, so just so I'm clear, if a law enforcement officer uses this kind of restraint, they're going to be put to the task of explaining that they were acting in defense of their life and subject themselves to potential criminal prosecution under this statute. Okay. Thank you very much.
Ms. Ballinger, did you have something? No? Okay. Any further questions from members of the committee? Seeing none, what's the pleasure of the committee? Mr. Pack moves due pass House Bill 911 LC 344012 ER, second by Ms. Dickerson. Are there any amendments? Seeing none, any further discussion? All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Ms. Ballinger.
Where they see most opportunities of crime or theft happening, they alter or tamper with that fifth wheel. It also gives the GBI original jurisdiction. What we see most often is this crime is multi-jurisdictional and lasts for an extended period of time. We see some of these operations have upwards of a year or 2 years worth of folks being planted inside an operation to understand shipping schedules, understand cargo that's specific cargo loads that are going out the door. And so we feel like the GBI is best prepared to be able to handle that multi-jurisdictional task and also that extended timeline. Ms. Travis was not the author of this bill to start with, but she has been so gracious as to provide some additional comments that we've gone through in quick nature, but I've actually reviewed them, and at some point like to possibly go over those with the committee to highlight some of the mostly drafting issues that, and I have no challenges to or no issues with the edits that she's proposed.
You want to offer that in the nature of amendments?
I would.
Later on
at the appropriate time, I would.
All right.
So with that, I'd like to take any questions that you've got. I will say that in subcommittee, it was a great opportunity to perfect this bill. We made a couple of changes to it. One was to add a definition, excuse me, of what a fifth wheel is, and the GBI did a great job of going back to what we currently have in the DOT code as to what a fifth wheel is, and then we defined that. In addition, Chairman Pack had a question about value, and so going out through the industry and looking for opportunities to get that right, we put fair market value as defining value for that. We feel like the courtroom, that narrows it down to where the courtroom's the best setting to figure out what that value is going forward.
What we'll do is I'm going to ask for a report from the subcommittee chairman, vice chairman, Representative Pack. Then I'm going to ask counsel, if she would, to go over the issues that Representative Duncan just referenced, and then maybe we can go over those first, and then we'll get to questions, because some questions may be solved, may be cured by just going over that one by one. Okay. So with that, let's get a report from the subcommittee chair, Mr. Pack.
Thank you, Mr. Chairman. We've actually had several hearings on this bill to address any interested parties have an opportunity to speak on this. A couple of things that highlight that we felt that was necessary for application and practical purposes was to define what a fifth wheel was. I think that was a question that many people had. Second was the value, because the penalties are the thresholds are numerical. We thought that since value can be estimated whichever way, there's several different ways to do that. It might be fair to just pick one, and so Representative Duncan has located that the fair market value is the value that the court should use, and I think applying the legislation, if it passes all the way through, would be much easier for the court to do that. There weren't many opposition, except for I think Gactel did voice some opposition to the threshold, but that was vetted, and the subcommittee voted on that and felt that these were appropriate values for the penalties.
How do we go through the process of ascertaining fair market value in this context? What are the mechanics?
I think Special Agent Cannon might be best versed to talk about how the values derived in the courtroom or fair market value.
That's usually decided upon by the judge and the prosecutors, which we're going to use, either retail, wholesale, or whatever. It's decided upon there. It's my understanding is what was discussed with the prosecutor.
And Mr. Spayhouse has also been one to help us walk through that, understanding that in a commercial relationship, and that was part of the conversation too, is this crime disrupts the stream of commerce. So there's an extended length to that. But going back to fair market value, because of that commercial relationship where you've got distributors and wholesalers, the courtroom is the best place to try to bring in those expert witnesses on both sides of the issue to derive what is fair market value.
Okay.
It was a very broad stroke, because if something's shipping directly from a factory but to a distributor, well, the fair market value is what that business relationship is in that environment, not necessarily what it might be 3 generations down the line in the production model.
Bottom line is the victim would come in and actually provide documentation what the loss actually is.
They're going to make a pitch for what the value was. How does the counter work in terms of who's to say what it is? The court will go and take notice of it. There may be experts brought in, and the court will just simply make a determination from the testimony and from the experts' opinions, I assume.
And that's what we've done in the past.
Okay. What Special Agent, from your experience, when Representative Duncan and I started talking about this in the summer and fall, and he's been on this issue for a long time, the first thing I thought of was just, well, to what extent is this enforced in the federal context? Because it just strikes me as being a very federal type of crime that you'd expect there to be sort of a normal enforcement and heightened enforcement at that level. Can you speak to that from your experience, or is it not as aggressively enforced maybe than we would think?
Terrorism today.
Sure.
And I think cargo theft falls like number 8 on their priority list, if I'm correct. So they've left a lot of that to the states to deal with.
Okay.
We've had, I think, maybe 2 cases that ended up in federal court because of the amount of theft and the interstate transportation aspect between where the cargo was actually stolen and where it was recovered. We've had a couple of them, but most of them are going to be prosecuted in the state.
Have you seen any, just speaking generally, obviously, do you see again, another one of my assumptions, which may be completely faulty, is would imagine that a lot of this theft is tied to narcotics, trafficking, and perhaps other larger organized crimes as a financing mechanism, or does it exist on its own, not just a financing mechanism for larger cartels of whatever those may be, but a focus in and of itself?
If I may, the two types of criminals that we're dealing with in regards to cargo theft, we have our local groups here in Atlanta who, and you can divide those into two different groups too. They do what we call pilferages, which they do go and shop at truck stops and just steal maybe a half of the load. The other group, they still hold tractor trailers. Those are homegrown local thieves that they have their outlets around here where they may sell it at some of the thrift stores or whatever, and they use their proceeds to, it could be for their drug habits or whatever. We're dealing with those. But then we deal with the other group, which are the ethnic-based groups from South Florida, who are the most proficient cargo thieves in the world. And a lot of times when they steal cargo from up here in Georgia, they transport it to Miami, and it's put on ships and it's sent to South America. And in some instances, it's been traced back where it financed some terrorism aspect of that. So we haven't really seen anything where it's going actually to finance any major narcotics organizations, but these are like organized theft groups here in Atlanta and the ones in Florida. They basically just use it to support themselves. It's their way of life.
But you have
make a living.
But you have connected the dots to terrorism.
Right. It has been in some instances in Florida, some cases down there, they have actually tied some of the thefts to groups who ship the stuff to South America and back, who the proceeds actually went to terrorism.
Thank you for confirming that. Questions from members? And thank you to the Vice Chairman for his summary. I see no questions. Thank you, gentlemen. Appreciate it. Let me ask, is it Mr. T.S. I can't read this. Is it T.S. Kaplan? That's right. With the Georgia Motor Trucking Association. Is it Mr. Kaplan? Is that right? Yes. All right, good. Lucky guess.
Thank you, Mr. Chairman. Like you said, my name is T.J. Kaplan.
T.J. Kaplan, I'm sorry.
Represent the Georgia Motor Trucking Association here on behalf of Ed Crowell. We just wanted to express our full support for the bill and thank Representative Duncan for all his work on this, and thank you, Mr. Chairman.
Thank you, Mr. Kaplan. Is Mr. Rotundo back? He is not. All right. Mr. Spayhouse, anything?
No, we're good and supportive. Help the author with the bill and feel like it's a good bill.
Thank you. All right. It's back with the committee. What's the pleasure of the committee? Ms. Dickerson moves due pass of House Bill 749, LC 28, 7041S. Second by Mr. Strickland. Are there any amendments? Seeing none, any further discussion? I'm sorry. I never came back to council to. My apology. My apology. Better late than never.
It's going to sound like a lot, but it's really not that many.
Okay.
Let me try and walk you through. Looking at line 13, take out the notwithstanding any provision of this chapter to the contrary, because the only provision to the contrary actually is stricken on lines 85 to 92, so that's just crux language, which we can take out. So the sentence would begin with a person commits. May I just keep going?
Please.
And then looking at lines 22 to 26, this gets problematic because that's what we call undesignated text. And I'm going to would suggest fixing it three ways. One is the operative language, which is on lines 22 to 23 through appropriated. Move that clause to the end of the sentence after thereon on line 18 and after agency on line 21, so those are complete sentences. Move the definition of the term vehicle to the beginning of the code section, because we always start with the code section having definitions at the beginning. That would necessitate renumbering some of these things, relettering rather. The next change would be at the end of line that's the one that's an overlap. So I think it should say the enactment of Code Section 16A22 rather than this act on both lines 100 and 101. The other option would be 16A22 and 16A23. I think it's only 22 that's the issue, but it might be good to get into that one.
Mr. Spaus, I know that was quick. The
I'm not on the same version, so I couldn't follow.
Are you on 7041S?
No.
Let's take a moment.
Because that's the behavior. Right. Yeah, but those are the theft cases that are being prosecuted under this or the lesser. So the safe thing to do is to have both of them. Pretty much of it.
So he thinks we should add both 22 and 23.
You could be prosecuting under a different theft code, but with different penalties, the same act. So I think it is covered, but the same thing would be cite both those sections.
So the enactment of Code Section 16822 and 16823 in those two locations shall not affect prosecutions occurring before the effective date. Let me take a look at.
Yeah, the only other thing I thought is, we've had this discussion before about the language at line 13, and I think the goal of the language, and I'll certainly defer that the best way to do it, was to make crystal clear that you don't have a rule of lenity issue here, because this could be prosecuted as a basic theft, but because the cargo is in commerce, affects more parties, and affects like a normal theft is generally from an individual, because this is in commerce, it affects a great deal of individuals. This stepped up punishment is here for that, and that's designed to prevent it from having to go down to 16.8.2.
So then, if you want to keep it, it would say notwithstanding Code Section 16.8.2 or 16. You give the specific.
The specific
this
code
is what we
section.
call late draft.
No, I don't agree with that. I don't disagree with that, but I think what we're trying to do is prevent your requirement in the sentence at that point under a regular theft of anything that theft covers. So you would almost have to do anything else in 16.8, because you could have livestock, you could have the other things that are covered with specific theft crimes that could be in commerce.
Well, you could at least narrow it to Article 1. Right?
That would prevent the
Robbery. Chop shops. You can't get that.
or any of that would matter.
Residential mortgage fraud.
What you're trying to prevent is the requirement to sentence under the lesser offense and something in Article 1.
Right. So we changed line 13 to say notwithstanding any provision of Article 1 of this chapter to the contrary. And then A would stay lowercase.
I'll offer that in the nature of just one administrative cleanup structural amendment. Are there any questions or concerns, though, from members of the committee? Anything not clear? It seemed pretty straightforward, other than the potentially the last point. Can we just get a summary of the last point?
On line 13.
Yeah.
So when somebody reads that, you don't know what the reader doesn't know what's contrary, who's on first,
Right.
so to speak. So you would want to try and direct the reader
Okay. Thank you, both. Is there any objection to that collective amendment? Seeing none of that's adopted. Are there any other amendments from members of the committee? Seeing none, we've got a motion and a second. We have the one amendment. The move do pass by substitute for HB 749 LC 287041S. All in favor say aye. Opposed? The ayes have it and the motion is adopted. Thank you, Mr. Duncan. Mr. Tanner.
Thank you, Mr. Chairman. I'm going to be asking for favorable consideration for a substitute to House Bill 838, just to make sure we're all on the same reader. It's LC 295910S. And I appreciate, at the start I'd like to say I appreciate Chairman Pack's subcommittee and their work helping with this bill. We made some changes to it in subcommittee, which I think makes the bill better. Also, I want to say that after the subcommittee meeting, I met with the minority leader who had a suggestion which incorporates this substitute that's in front of you today, and I'll cover that during my presentation. In short, this bill is an attempt to address an area of the law where technology has changed over the last several years, which has made the ability to commit certain crimes and harass certain people different than they were even 10, 15 years ago. This bill attempts to get to, and I think the best way for me to explain the intent of the bill is just to give you an example. If you have a young lady, maybe 18 years old, that's in high school, or a young lady in college, or even a young lady or a man in a marriage or relationship, and they allow a photograph or their spouse, significant other, friend, someone has a photograph or a video or something sexually explicit of that person, 6 or 7 years down the road in the future, that person has forgotten they even knew that individual. Maybe they're married, they're in a professional job, and all of a sudden they start hearing rumors that their video or their picture has shown up on pornography websites, or is being emailed out to friends, neighborhood committees, or posted in general on the internet. There's nothing under current law criminally that they can do about that. And this bill, there's 15 states that have either passed laws or are in the process of considering laws that would address this, which is commonly referred to as revenge pornography. In working with PAC, Prosecuting Attorneys Council, we came up with the idea of calling this intimate harassment. There was a concern that revenge pornography further victimizes these individuals who are victims of this, and many times these situations happen in domestic violence type instances where these people have already been victimized in multiple ways. The bill, the part that we changed with the suggestion of the minority leader is originally in the bill I had it as a felony 1 to 5 for first offense. She suggested, and I agreed, that we should change that to a misdemeanor of high and aggravated nature for first offense. If it was a second offense, it would be the 1 to 5 felony conviction. And again, the idea there is if you have an individual maybe who is a college student who makes a mistake and does something because they're mad at their girlfriend, they're not going to be tagged with a felony, but the repeated behavior does rise to felony nature. Just going through very quickly, the intent is on line 23, a person commits the offense of intimate harassment if he or she knowingly and without the consent of the depicted person electronically transmits or posts. Originally we had that they posted it to the internet, but the idea through subcommittee was electronically, which I think is more all-encompassing of the intent of the bill. It transmits a post or photograph or video which depicts nudity or sexually explicit conduct of an adult when the transmission or post is harassment, and harassment is defined earlier there in the bill, or causing financial loss to the depicted person and serves no legitimate purpose. I will tell you that in the number 2 there on line 29 goes to the intent here is the person who transmits it could be charged. or if you had someone else transmit it on your behalf for the purpose of causing this harm, they could also be charged under this code. There are some exceptions that are listed out under Section E that you can, I'll be glad to answer any questions on. During subcommittee, we did add the one relating to the line 52, if it's done in a public setting, you got someone who's intoxicated and they're in a public park and they're streaking through the park and people are taking videos or pictures of that person and posting it on Facebook. It's not the intent of this bill to charge those individuals criminally, and that would be an exception. I have worked with various First Amendment groups and attorneys in drafting this legislation in an attempt to make sure we balance the First Amendment rights of individuals who have these photographs, and we had no negative comments made or testimony during subcommittee. One last thing, Mr. Chairman, and then I'll answer any questions that you have. I have been approached by members of the industry relating to the computer industry, the telephone industry, with one concern. They said they have saw in other states where prosecutors have attempted to prosecute maybe an internet provider for allowing this type of behavior to occur on their service. In talking with the Prosecuting Attorney's Council and with the GBI and others, they don't see that as an issue here in Georgia, but we did draft some language as an amendment for your consideration from Legislative Council, and this amendment basically would state this code section shall not impose criminal responsibility on any entity that facilitates an electronic transmission or post. Now, I'll tell you, in conversation with the industry folks who are here today, and I think they'd be happy to speak to this, they're concerned that that may not be broad enough to cover their industry. They had originally asked that it read, nothing in this act shall be construed to impose liability on any interactive computer service as defined in 47 U.S.C. 230 F2 for content provided by another person. So my intent, of course, in drafting this legislation is not to criminalize or to try to prosecute the individuals running computer companies or telephone companies. It's going after the individual who has an intent to harm. So I'm definitely open to any amendment this committee would like to consider relating to that.
Let's get a report from the subcommittee chair, Mr. Pack.
Thank you. I think the initial concern was this is a trend. It hasn't been tested in the courts with respect to the First Amendment. We've done some additional research, and I myself looked at some research. It looks like the definition that we've taken with items that depict nudity and sexually explicit conduct, those are squarely within the exception of the First Amendment for obscenity and defamation. So I think we're on safe ground there. In addition, there's additional protections built in, and Representative Tanner has really worked very hard on this. The definition of harassment includes a substantial component, which certainly is not a willy-nilly. If you imagine a naked photo being posted somewhere on the internet, you can imagine that everybody would be embarrassed, but we're talking about trying to narrow that definition and the intent to cover those situations where it was directed to cause that person some type of harm. And second thing, with respect to the public exception here, I think the intent was that we're trying to get at the disclosure of private facts, public disclosure of private facts. As a result, you have an exception here for if you're going around, streaking, whatnot, somebody takes a video of that, you really don't have any expectation of privacy, and hence is also a kind of a consent, like an implied consent for that. So that would not be covered. We did not address the one issue that I think the ISPs bring up, and I would like to take a look at the language on that. But one concern that I may have, including that, is you wouldn't capture people who are supposedly on the revenge porn website, which was the intent, I think, the impetus of the bill. I would have to look at the definition of that statute, the USC code, but I'm a little concerned that the exception will swallow up the rule, because you could actually be your own internet service provider and post the pictures and you'd be excluded. One thing that I think may that we added this on here during subcommittee, which addressed that concern, would be in the definition in lines 23 and 24, because you have to knowingly post it, which ISP, if they know that this is not without consent, then certainly they should be covered. And I think most ISPs, through their agreements and their click-on protection when you sign up, says you're not doing it for any other illegal purpose, so they would be covered if they have that set. But I do think that we should be careful about adding the language, excluding ISPs. I could see how that could be abused. Thank you.
Thank you. Questions for the author? Mr. Hightower.
On line 23, when it says intimate harassment, I see where you've defined harassment, and it actually took, I think it took some of my concern away, because it's intended to cause substantial emotional harm. I think that's where your intent to cause harm comes in. But you have kind of titled this intimate harassment. Am I missing? Did y'all define intimate somewhere, or are you just calling, or is that just what they're committing the offense of intimate harassment, but harassment in line 23 is going to go by the definition in line 13?
We did not. The intent there is for the code to ultimately be called and named intimate harassment. There's not a separate definition for intimate. It's just it was placed there as the term that would be used for this specific code section.
Okay. But the word harassment in line 23 is going to be using the definition from line 13.
Correct.
Right?
Correct.
Okay.
And just can I follow up, Mr.
Sure.
Chairman? And Chairman Pack brought up the same point that the Prosecuting Attorney's Council brought up when I followed up with them on the issue of exempting the electronic providers, is that there's no intent element there on their part. So they would not be able to prosecute them unless they could prove that they knowingly did it without consent. So they could see no instances where they would prosecute under this type of case. And Legislative Council brought up that we have other laws on the books, child pornography and other things, where we don't have those exceptions. The industry said that in other states they ran into this as an issue. They have not had that happen here yet in Georgia. Again, I'm open to that. My intent of this legislation is not to go after the companies who provide internet service, but the company who they're in the business of having folks pay them to display these photographs that they know are not consensual. Those are the type of people we want to have stop doing that here in the state of Georgia.
One follow-up.
Sure.
On going back to the definition of harassment for you, so the way that I'm reading this, and make sure your understanding is the same, you have a couple, husband, wife, boyfriend, girlfriend, whatever the case may be, and the female sends a picture of her unclothed to her husband or boyfriend, whichever the case is, and that gentleman then goes and shows a friend, or transmits it to a friend, texts a friend, says, "Man, look at this hot smoking lady that we have here." He didn't do it to cause harm. In that situation, he would not fall as a violation of this. Is that right?
That's correct. It would have to be done with the intent to commit that harassment. So that would have to be a fact that would have to come out during the court process. But if there was no intent to cause that harm and that wasn't proven, then he would not be guilty under this code. That's correct.
Mr. Coomer.
Thank you, Mr. Chairman. I'm really just kind of struggling with this definition of harassment, lines 13 and 14. And let me just kind of walk through my concerns, and maybe you can help me figure it out. Harassment means engaging in conduct directed at a depicted person that is intended to cause substantial emotional harm. The three things I have concern about: number one, what does it mean when it says conduct directed at a depicted person? What is conduct directed at a particular person? And does that mean if the person transmitting the image transmits it only to the person who's the depicted person, is that the only way it can be directed at the depicted person? I'm not sure I understand where that is heading. And then secondly, what is a depicted person? It's not defined. I mean, I guess we could assume that a depicted person means somebody whose image appears in one of these videos or photographs, but we probably should define that more succinctly, or would define it, period. And then the last part is cause substantial emotional harm. And again, that phrase is hung out there, but it doesn't say to whom the emotional harm was caused. I mean, would this be the same if I intend to cause emotional harm to somebody's child by showing a naked picture of that person? Or or do I have to intend to cause the emotional harm to the person who's in the image? So I'm just struggling with exactly what we're trying to get at in the definition part of harassment.
That definition was not in my original bill. That actually comes from other law. I know that it was added during subcommittee at subcommittee's recommendation, and I think legislative counsel may be able to help me. That definition came, or Chairman Pack may be able to help me. That definition actually came from a specific place in the law. Stalking.
Where the language, similar language is used, where we, in the stalking statute, we say directed conduct directed at a specific person which causes emotional distress.
Yeah, like following them around or texting them over and over. I get that. It makes sense in that context. I don't think it makes sense in this context to say that the conduct is directed at a depicted person, if that's the person in the image, because you're not sending the photos to that person to cause them emotional harm. I'm assuming you're sending it to a website or putting it out for public consumption. I mean, I guess, unless I'm misunderstanding what the bill does.
Yeah, you have to read the second part.
Yeah, you got to read the whole thing.
Just not the definition of harassment, but read it in context.
Okay.
So go to page 2 and insert the words. Take out the word harassment, and then insert the words, and then see if it makes sense. The issue that Representative Hightower brought up with the name of the crime and how that's a little confusing is sort of an issue. But in the context of reading, putting the way you're supposed to use the definition and putting it in, I think it makes sense.
I think that helps me with understanding what a depicted person is, reading that in context. And then there is conduct that's described that you could use. I still have a problem with the substantial emotional harm part. In terms of, are we intending for that substantial emotional harm, is that to the individual depicted, or is that to any person at all?
To the individual depicted.
Okay. All right, thank you.
Ms. Dickerson.
My question is that with this, only the person that is doing this, putting the picture out on the internet, wherever it's at, they're the only ones that would be punished by this, and you said not the company, correct?
Well, it would be the person being the person putting it out, or if there was someone else that had someone act on their behalf. So if I gave you a photograph and I said, "This is someone I'm upset with, I'm mad at. Can you send this by text message? Can you post this on the website?" And you knew there was an intent, that you knew that that person had not consented to that, then you could also be charged. But an internet service provider that I use at my home, and then I use that provider to send out these photographs, there was no intent on their part to commit a crime, so they would not be prosecuted in this case. Is that clear?
Yeah, I just wanted to be sure it was that any person, because at first you said the person, and then I'm looking at the one person, and then you said something about the company that would be held liable too, and I just wanted to know what company you were talking about.
Well, they're
not the internet provider itself.
No. There's companies that have established themselves, and you may have saw some of these actually on the news nationally, have established themselves as, quote, revenge pornography websites. And you can actually go onto one of these websites and upload a picture of someone you're mad at, that you may have a picture of that person. You can upload that photograph, and they'll publish that on their pornography website. Those companies are different than in a company like AT&T, who provides internet service. Those are the other companies I was referring to.
Okay.
Yes, ma'am.
Thank you.
Sorry for the confusion.
No, I didn't know of those kind of companies.
Yeah.
That's what I was asking.
Yes, ma'am. Yes, ma'am.
I see no further questions. Thank you, Mr. Tenner.
Thank you.
Oh, Mr. Hightower.
going back, would it, and Jill, maybe you can help with this, would it make more sense to, on line 13, and instead of just having harassment, to make that intimate harassment?
No, the way to potentially fix your concern would be to take out the word intimate harassment and say a person violates this code section if he or she knowingly.
So just take that part out and
Yeah,
leave the harassment so it's defined elsewhere.
Well, I think you would just say a person commits the
Okay.
offense of this code section.
A person violates this code section. No, this code section.
And I'm fine with that, Representative. The intent there was just to create the name within the code, but it would be difficult to come up with a way to define intimate. So if that makes it better, I would be open to that.
Jill, how would that read again? A person commits the offense.
A person violates this code section if he or she.
Yes.
Thank you, Mr. Tanner.
Thank you.
There's no one signed up to speak on the bill. Is there anyone who'd like to be heard on House Bill 838?
Chairman, if you will, Michael Wall with Comcast, I'd love to address the
All right. If you could keep your comments brief, we'd appreciate it. We've got one more bill.
I think Representative Dickerson left, but to kind of, I guess, expound upon what she was speaking of. We are the companies, we're the ISPs, obviously, that are the intermediary ISPs that would be handling this information that's posted. What we see with the bill that causes concern for us, that we've seen across the nation in some cases, is that it really hinges on knowledge rather than intent. And there, depending on how broad you construct that statute, you could in fact find constructive knowledge. So that is why we were more interested in finding some protections for the third-party intermediary ISPs, if you will. The language we gave the sponsor is actually in 47 U.S.C. F2, and what it is it's interactive computer service. I was going to read it for you. It says the term interactive computer service means any information service system or access software provider that provides or enables computer access by multiple users to a computer server, including specifically a service or system that provides access to the internet, and such systems operated or services offered by libraries and educational institutions. As you can imagine, there are 21st century classrooms, there are public libraries, there are other institutions that provide access to the internet, that provide access to the technology that these folks are using to seek revenge, if you will, or intimate harassment, and this would protect both the ISPs as well as those educational or libraries.
Yeah, I think we understand the issue. I appreciate your comments. Mr. Tanner, did you have an amendment printed by any chance that you wanted to offer, or no? At the appropriate time? How did you want to handle that before we get into it?
I have the committee that, when I brought this issue to Legislative Council and the concern and my openness to try to find a good way to address it, they did draft a substitute to this amendment. Again, doesn't go as broad as what we just heard, but it says it would be under G, this code section shall not impose criminal responsibility on any entity that facilitates an electronic transmission or post.
Chairman, if you will, just to clarify, we think that's too broad, and we were trying to narrow it.
Okay. We haven't gone to a motion yet, but what we could do is we could entertain an amendment right now and then potentially move the bill. Or we could, presuming there's a motion and a second and a vote to move it out, we could continue the conversation in between the time that is here and potentially on the floor, and that would allow you more time to come to a meeting of the minds on how that issue is to be handled under a modified open rule, and I wouldn't presume any controversy on the subject matter generally. but I'm going to leave that to the author as to how he wants to handle that. I don't presume that there would be any problem with an amendment on the floor.
If the committee would be willing to do that, I would ask that we consider moving the bill, just because as time starts drawing short, and then I can work with the industry and legislative council to try to come something amenable to everyone involved.
Yeah, and we're just being respectful of our time and, frankly, your time as well.
Yes, sir.
I know you've worked very hard on this bill, so we want to make sure that it's done right, but we also want to have just a collective, public, transparent understanding of what we're probably going to go ahead and look at in the nature of an amendment going forward.
Yes, sir.
Okay.
There's a lot of comments for that CFR language. It uses a ton of different other definitions, so it would be about a page long.
And that gives council time to ferret through that.
And that's why we came down to one sentence.
Right, one sentence. That sounds good. Any questions or concerns from members of the committee on that approach? Mr. Coomer?
I'm sorry, not on that approach.
Okay.
I just want to issue while we've got the author sitting here when it's appropriate.
Fire away.
Going back to the questions I had on 13 and 14, just kind of written out some language, and before I offered as an amendment, I wanted to run it by you and see if you would think this would work. Harassment means engaging in conduct described in subsection B of this code section with the intent to cause substantial emotional harm to a person depicted in a post, photograph, or video which depicts nudity or sexually explicit conduct of an adult. The reason I put it that way is because it gets at, it tells you what the conduct is. It's the conduct described below. It clarifies that you're talking about the person who's depicted in these videos, and that the emotional harm is intended. You're intending to cause emotional harm to that person. I know I've read it out to you real quick, and I'm glad to read it again if that would help.
You can't use a subsection definition because now you've made it circular.
Okay.
When you have a definition, you have to take after the word means to the end of the sentence and put those words in instead of. So like when it says department means Department of Public Services, it's very easy to read it. But when you have a whole lot of words afterwards, it makes it far more complex. That's a difference.
Yeah. Well, I think the simplicity, to me, the simplicity we have creates confusion, or at least ambiguity. But
And I will say this, not that it will matter, but there has been a great deal of thought put into trying to find the best way to define harassment. Originally, we just used the word harassment and did not have that definition, which is used in other code sections throughout our law. But there was a desire to define it out, which we met with the Majority Whip and with Chairman Pack and Legislative Council in Legislative Council's office, and discussed this at length, a way to define it. And the language you have in front of you is a result of all of that work from the various parties involved, not just myself.
Okay.
So I'm definitely open, as long as it doesn't change the intent of the legislation. Not to sit here and claim I have the best solution, but I can tell you a lot of different folks have worked on that very issue.
Any other questions, members of the committee? Seeing none, what's the pleasure of the committee? Is that a question? Mr. Hightower.
Coomer, this may not, or may help, it may not. It doesn't go to resolve the conduct directed, but at the end of the sentence, after harm, you could just state again, to the depicted person. That is intended to cause substantial emotional harm to the depicted person. And since we have earlier in the statement conduct directed at a depicted person, that would at least center up on who we're talking about. But it doesn't clear up everything, but it gets half of it.
Let me just read, and I have learned a lot from doing this bill from Legislative Council, and what she has explained to me, and she can correct me if I'm wrong, is when you're reading this, she said I would need to insert the definition where the word harassment is. So if you were reading this, it would say electronically transmit or post in one or more transmissions or post a photograph or video which depicts nudity or sexually explicit conduct of an adult when the transmission or post the person is engaging in conduct directed at a depicted person that is intended to cause substantial emotional harm or causes financial loss to the depicted person and serves no legitimate purpose to the depicted person.
All that I would change with that is at the end of your sentence on line 14, you would say, after harm, you'd strike the period and put to the depicted person, period.
Okay.
And that
Okay, yeah, and then it would, or causes.
Yes.
Sounds good.
Let me ask for a motion. Do pass HB 838 by substitute LC 295910S. Mr. Pack, Ms. Dickerson, second. Any amendments, Mr. Hightower?
Yes. On line 14, I would strike the period and add the words to the depicted person, period. Mr. Chairman, I have one other amendment.
Okay. Oh, well, is there any objection to the first Hightower amendment on line 14, strike the period and add to the depicted person, period? Is there any objection to that amendment? Hearing none, it's adopted, Mr. Hightower.
Second amendment, Mr. Chairman, would be on line 23, and it would be to strike words commits the offense of intimate harassment and replace that with violates this code section. So 23 would read, a person violates this code section if he or she knowingly and without the consent. Everything else is the same. I just think it would clear up a little bit of confusion on how you're defining harassment. The way it's worded now, intimate harassment seems to go together, and we're only defining part of that phrase or term.
Mr. Hightower moves an amendment on line 23 to strike the words commits the offense of intimate harassment and insert the words violates this code section, so that subsection B would read a person violates this code section if he or she knowingly and without the consent of the depicted person, colon. Is there any objection to the second Hightower amendment? Hearing none, it's adopted. Are there any further amendments? Any additional amendments? Seeing none, we've got a move do pass by substitute of LC 295910S and a second. Seeing no further amendments, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, the motion's adopted. Thank you, Mr. Tennant. And we'll be in contact on that potential amendment on the floor. So maybe we'll talk before rules at some point the next day or two. I'm assuming you'll be asking for it tomorrow.
Yes.
Or do you want to allow for a little more time?
I may wait till the day after just so we can see.
Could I suggest that you come and ask for it and just make sure it's clear that there'll be an amendment forthcoming, but that way you've got the request in under the whole time concern that we just talked about?
Yes, sir. Thank you.
Okay. Mr. Strickland, House Bill 845. Thank you for your patience.
Thank you. I'll stay up here if that's okay.
Sure.
Mr. Chair. I'm
No
working
problem.
from a substitute. It's LC 295923S.
Does there a member of the committee who does not have that substitute?
This is House Bill 845.
Okay.
All right, members of the committee. House Bill 845 deals with arrest photographs in the Open Records Act. If you recall, last year, Representative Roger Bruce brought a bill, House Bill 150, which dealt with these website companies like Busted.com, I think is one, Mugshots.com. These companies that actually take images of individuals that have been arrested and display them online, and then they will offer, if you pay them some as much as $300, they'll actually take your image down. And individuals that have been charged with crimes, though the offense is later dropped or they use first offender, they find out down the road their image haunts them the rest of their lives, and the image stays out there. And the only way to take it down is to pay these folks money. And the bill we passed last year dealt directly with that, and that bill made it a crime. Well, actually what the bill did is, I don't know if it made it civil or if it made it criminal, but it said that once an individual actually writes to one of these website companies and confirms that they were not found guilty, they use first offender, several exceptions they have, the companies must take the image down without charging a fee. Great bill. We passed it. There was very little opposition last year to it all. Passed the Senate and signed by the governor. Only problem is now we're having trouble enforcing it, and we're finding these companies are actually now overseas. I directly dealt with this issue with a couple different clients. I won't go into too much detail with that, but I can tell you, individuals had tried to comply with House Bill 150 last year. They sent the correct language in writing to these companies, and companies are refusing to take the images down. And I won't speak for anybody else, but I can tell you that there's no one out there that's willing to go enforce this law, because it is seen that this law is unenforceable. These companies are now overseas. The idea of trying to get Georgia law to apply to them just isn't going to work. And if Congress were to act, still, these companies are taking images, putting it online, and they're based offshore somewhere. So this bill gets directly to the main issue. And what this bill does is it says that once an individual has been charged with a crime, the arrest image does not get released till the person has been found guilty of that crime. And found guilty also works if you actually plead guilty as well. So once someone is just charged with a crime, the old notion of innocent until proven guilty still stands. That person's image will not be displayed out there online for anyone else to see until they're actually found guilty. Now, if they are found guilty, or they plead guilty to the offense as well, at that point the image comes out. And so just like a full police report that's not released to the public until an investigation is complete, this situation, the image itself will not be released as well. Media, anyone else can get information about an arrest that took place, but they can't get the image until someone has actually been found guilty. Adjudication of guilt has occurred. Now, I've worked with members of legitimate media, and I say legitimate, those that are actually out there acting as media and not exploiting these photos. And their concern is with this bill being too all-encompassing. It's going to actually prevent members of our legitimate media from publishing images of those that have been arrested. And I've tried to come up with ways to draw this less, I guess, more narrow, if you will. Every example I can think of, everything that's been offered to me, still puts these images out there. If a legitimate media source gets an image, we draw it to where only certain folks that are regulated can actually get these images. They still display it online. Even I, not very technologically advanced, but I can take a picture and take a picture with my cell phone and republish it on Facebook myself. These companies will still get the images. The substitute did address two different issues, though, that I did see in looking at the draft of the bill. One, the first draft of the bill didn't define what crime was. And it said an arrest booking photograph unless the person in the photograph has been convicted of a crime. Didn't say the underlying crime, didn't define what crime was at all. So the substitute actually says that convicted of the crime for which such photograph was taken. And one concern that I know PAC had was to make sure that when someone has the charge changed, you're originally arrested for DUI, you end up pleading to reckless driving. My understanding is this draft from Legislative Council, my understanding is this draft would still cover that crime. So whatever crime you're arrested for, whatever facts it is, your image would come out if there's a finding of guilt down the road. The other issue I saw is there are some people that want their image displayed for whatever reason. I know in the civil rights era especially, people wanted to have their images out there for everyone to see so you could see what the government is doing to people. And so this allows any individual to have their image released at any point, and also a legal representative of that person as well in case that person is deceased. One thing I thought of is someone's arrested, they are allegedly roughed up in the arrest, they pass away. Well, the first draft says the image could always be held by a sheriff. And so this draft actually allows the image to be released by a representative of the deceased or an individual as well that's been depicted. And finally, one concern I heard was the issue of someone that is arrested, first offense, they bond out, they don't show back up again. The best image we have is the arrest image of them, the booking photo. And so under 50-1877, there's a catch-all that allows the depiction to be released to law enforcement for basically any law enforcement reasons, my understanding of the way that code section is written. It's very vague in the sense that a grand jury investigating a crime or law enforcement could always get an image, still always release an image. And also, my draft here also doesn't say a sheriff can't release these images. It just says they don't have to. So some sheriffs may choose to still release these images at all points. This just actually says what is considered part of an open records request. We have some members here from Reclaim Our Dignity, a group that has worked hard on this issue the last couple of years. A lot of victims out there that have, like I said, either gotten in a bad situation or used first offender. They try to apply for a job, or I don't know, they're teaching in a classroom one day. These images come up and they're haunting the rest of their lives, and they can't make it go away unless they pay. And once you pay one website, and their website wants to be paid as well. So I'm happy to work with members of the committee to make this any more narrow that we can, but it's just, like I said, I still have the issue of if an image is released to a legitimate source, these companies can still get the image at that point as well.
Questions for the author? Ms. Kendrick.
I'm sorry, I have to use the mic right in front of
I
you,
know.
but so everybody can hear. So on line 24, that talks about the definition or the term convicted, and it's irrespective of the pendency or availability of an appeal or application for collateral relief. So what happens in the situation when they would win on appeal?
When they win on appeal?
Yeah, if they were found guilty and they appeal and they win on appeal.
Well, the current draft here, unless I'm reading it wrong, I mean, that's one area where your image does come out. So if you've been found guilty by a jury, then your image is going to come out at that point. Because you also have the issue of a habeas corpus, which I think has to be brought within 2 years, I believe, of finding a guilt. So you have a time period there where things could linger. It's my position is if a jury of your peers finds you guilty of a crime, at that point it should probably be released to the public. The image itself should come out at that point. So once a jury finds someone guilty, it will come out.
Yeah, I agree, but I'm asking about what if they appeal it and then it's reversed.
Well, it's already out at that point. So I guess if it goes back to a new trial, at that point the image is already out. I don't think it'd be retroactive in any way where all of a sudden the image is not allowed to be displayed. I know you're asking, but I don't think that scenario would fit here, because I think once it's been released, it's been released. It's subject to open records request.
I'm just wondering if that sort of defeats the purpose of the deal.
And I'll tell you, I don't think, and most of the situations I'm hearing about in dealing with this, situations where someone does use first offender or a case is dismissed, those are the ones that really have the biggest issue with this. It's not so much those that have been found guilty and go through the criminal process that long and appeal that verdict that are really being victims as much, or find themselves victims on these websites as much. I think we could draft it where it actually captures all appeals as well, but then you're looking at a situation where someone is convicted by a jury and the media must wait, unless I'm reading it wrong, must wait at least 2 years to release the image at all.
No, I'm not even
so
saying.
I think it's too far.
I'm not even saying wait to release it. I'm saying if you release it and then you find on appeal that it's reversed,
right,
then what's going to happen after that period?
Well, at that point, the image is already out there. The website's already going to have it. I'm aimed at anyway, so I don't know if there's any worry about that. I know what you're saying, but in that situation, the damage has already been done once the image is out there, because these websites will not comply with whatever law we pass anyway.
Ms. Randall. I'm sorry. Mr. Gravely.
Thank you, Mr. Chairman. To the author, yeah, I've got a question because I've got a similar bill dealing with disclosure. And I've been noticing, I've been a little bit more mindful in the evening news, watching 6, 10, or whatnot. And I guess my question is asking, does this bill pertain to that, or if someone can answer the question? When there's an arrest in the evening news, does a story cover that? I've noticed it quickly goes to the booking photo or the mugshot. And I know Representative Bruce's bill addressed the internet companies or the websites that will not take it down. But my question on this was, does this bill address the release to any news agencies if they're running a story? There's obviously in some of the scenarios there's not been a conviction or a plea at that point. There's just been an arrest made, but yet during that coverage, and if we're thinking about that, you can pull that video off of YouTube or any other video outlet where it would run the reel and actually just show the booking, shows an image of the individual. Does this bill address that?
It does not address the actual video that a sheriff's department may have of someone going to be mugshot. But the mugshot itself, yes, it would. The news story be changed from this person was arrested for this offense. Here's their image. This person was arrested for this offense.
And so it would be absent the image.
It would be absent the image itself. And that is one concern that I'm hearing from legitimate media, is they feel there's a public need to have that image displayed. Now, if we want to make that the policy, there is a public need for that, then we're going to have to let these websites operate how they're operating. The only way I can see to cut off these websites is to get to the source of it and say that in Georgia, when you're charged with a crime, everyone can know you've been charged. But we're not going to allow the image that we as a government take of you, this compromised position, be displayed for the whole world to see. So that is that's what's at stake here, though. The media will not have that right anymore under this bill.
Mr. Peck.
Thank you, Mr. Chairman. Two kind of questions. I too have been working on this issue since Representative Bruce's bill last year, and I foresaw kind of the problem. One issue is the press's First Amendment right to access to records doesn't really extend beyond what you and I have to access to records. Question I have is, can you ban access to those records, like the booking photograph? Wouldn't the better approach be ban sheriffs or any law enforcement agents from disclosing that? Then the question then becomes, if there is no First Amendment right to access those records, then you could eliminate all the press, because I think you have parsing out legitimate press versus non-legitimate press. In the age of blogging and things like that, it's virtually impossible to do. And I'm sure the Sheriff Association will probably oppose the bill if you ban that photo. The second thing is the concern that I have about is, I think you say the sheriff one sheriff could decide to release it and the other could choose not to. I can't really articulate it, but I think there's going to be like a unevenness of it, and type of, it's not, I'm not quite sure if it's a due process or equal protection violation. I don't think that is, but there's something about not being able to apply that law uniformly throughout the state might cause some challenges. So what do you think about banning the agencies and local government from releasing any booking photographs, making that a private investigative file versus, excluding out from the open records?
I don't have a problem with that. I want to make sure that it still can be released if law enforcement basically deems it necessary. If law enforcement sees a need to have an image released, and I keep going back to the example of someone bonds out and then disappears, well, there is definitely a public need to have the image displayed out there for everybody to see who this person is. And I would refer to legislative councils whether or not we could put this in somewhere else. When originally we drafted the bill, I didn't have the intention of giving the sheriffs that discretion. I was just told under this Open Records Act they automatically have that discretion. I don't want to fall back on sheriffs having to pick and choose what they release, because I don't know if they're the ones that should have that obligation. So I think we would be consistent on their responsibilities here. So either they release it all together, they release it, or they don't release it at all. And I think you have First Amendment issues where you start defining what is media. We start distinguishing who can actually run these images. And I've looked at some amendments to deal with that, to say, well, legitimate media will define can run images, but these websites can't. I believe that's where you may have First Amendment issues as well. If we choose to have it not released at all, I don't know if you have the same First Amendment concerns there. So I'll defer to legislative council on whether or not we could put this elsewhere. But I just want to make sure we don't put the strain back on the sheriffs too much here either.
Mr. Coomer.
Thank you, Mr. Chairman. Mr. Strickland, do you agree that there is a legitimate public interest in viewing the photos, or do you disagree? Do you say there is not a legitimate public interest in viewing these photographs?
I do not believe there's legitimate public interest in viewing the photographs, personally. Now, there are exceptions to that, but I do not believe that every single arrest is a legitimate public need in having the person displayed. I think with technology we have today, especially the name, the person, other information you may get to help identify that person is enough. We're not in an era where the only image that's available is the mugshot image. So I don't believe that myself.
Would you have the same concern if, let's say, law enforcement agencies, instead of having somebody presented in an unflattering way, if they were just, if they gave them a moment to clean up and put on makeup and fix their hair and it was a nice, pretty picture, would you have the same concern?
I probably wouldn't, because I think there's a stigma now of mugshots, and it's been created by these websites. It really is not the media. It's not the media as we know it, not the folks sitting out there that have caused this. I really think the websites have caused this and changed the stigma to a mugshot.
But you understand your bill keeps, as you refer to them, the legitimate media from engaging in what I would argue is a legitimate public interest. I mean, for as long as we've had newspapers that could print photos, they've printed photos in the blotter. So as I see it, I understand the concern, but it seems like there's no way to do it other than this, what I would describe as an overreach, but I don't see, I don't know how you do it in a more targeted way without getting into constitutional problems as you've identified, but I think you also have the same problems and probably going to face litigation and something like this. But.
No, I agree with you. And like I said, I've tried to come up every way I could to avoid something that is this broad. I will say this. One issue I have discussed with some folks with the media is allowing an exception to someone that has a felony record. And so an individual that actually has a felony record already in place, any subsequent arrest, at that point the image could come out. Those that are really, I guess it's a chance you can get caught up in a bad situation more than once and actually be innocent. But those that have been found guilty of a felony get arrested again. I'm okay with those images coming out. This is really to capture those that use first offender, which is up in our law, as a way to basically hold off adjudication of guilt on someone, allow them to actually have that withheld in the public arena as well. And like I said, I agree. This is very this is a very broad way of dealing with this. I just can't see any way of doing it.
Let me go ahead and call Reagan Marsh with the Georgia Press Association to come forward. Mr. Marsh, what is the public interest that is served by the publication of the photograph? Just the photograph, not the information collateral to the photograph, but the photograph itself exclusively. What is the public interest that is served by that publication?
Mr. Chairman, I think it helps you identify the person that is being discussed in the article. Also, it's a government record, and I think Georgia has been taking a stance of openness and transparency on records created by the government. So from just a general public policy standpoint.
What's the photograph telling the viewer that they can't otherwise learn from the text of the article or the copy that the newsreader is reading?
Well, I think it can help identify the person. If it's a person that has the same name or something like that, I think that's one thing it does.
Say that again?
I believe it helps the person that is reading that newspaper article be sure about the identity of the person that the newspaper article is talking about.
How can they be sure or not sure if they don't know the person?
Well, they can be a little closer to being sure if it's in a community newspaper where people know each other, or if it is a well-known person. Yes. Well, Mr. Chairman, our comments are just that we appreciate the bill sponsor working with us on this, and he's been very open to talk about this. And we would just ask to think about a more narrow way to define who this applies to. I don't think the Georgia Press Association members, which are all the legal organ newspapers in the state, I don't think that they are the reason why we've seen this legislation last year, this year, and in other states. It's not because of the way they're using these government-created records. It's because of a small minority of industry. And if we can find some way to narrowly define that, I believe that we can still have open records in a way that newspapers can use them, but maybe they're not used for the purpose that these websites are using them for.
Questions for Mr. Marsh? Seeing none, thank you.
Thank you.
And thank you for answering my questions. Skin Edge on behalf of Turner.
Mr. Chairman, members of the committee, thank you for allowing us to testify on this bill. We totally understand the issue and the problem that Representative Strickland's trying to get to. The problem is the way this is drafted, it does capture what I would call the legitimate news media who is trying to provide information, legitimate information to the public, as opposed to these non-legitimate websites who are really just trying to shake down people, frankly. A couple of comments on some of the questions that have come up. Mr. Chairman, to your point, the question, what is legitimate reason? I think Mr.
What are
Marsh.
they learning? What are they learning about, other than what color shirt the person had on?
Let me give you an example. This came to me as you just asked this question. I was reading the paper this morning about a lady up in I want to say Pennsylvania. I may be wrong. Who was just arrested for murder. Her and her husband met somebody on Craigslist. They murdered him, supposedly, allegedly, and now she's confessed to 20 other murders. The only photograph they've got of this lady is her arrest for this murder. Under this bill, you could not publish that photograph because she's not been convicted yet. The police, they brought in the FBI in this situation, I read. They are trying to determine if this lady is legitimately involved in these other murders or she's just insane and making this up. I think one way that investigation is going to be served, if you publish that picture, people in these other areas where these murders were committed say, yeah, I saw her, I didn't see her. It helps identify her, which is what Mr. Marsh, I think, was alluding to. So I think there can be some very legitimate reasons to publish this. It's newsworthy. We're here, this bill amends the Open Records Act. And I think any time you're going to limit the public's access to information, you've got to be very, very careful. And simply because you do have some bad actors who are misusing some of this information, you've got to balance that against the public right to know, the public's interest in knowing, and the public sometimes the public good in identifying someone who has violated the law perhaps in other situations. And that's a very delicate balance, but I think if it's close, you've got to come down on the side of the public's right to know. Now, I did discuss with Representative Strickland perhaps some language, and I apologize, I didn't have a chance to get it typed up, but basically some language to the effect that saying that this code section would not apply to an entity that publishes these photographs for a bona fide news purpose. And furthermore, any entity who publishes these and who offers to remove the photographs for a fee shall be deemed not to be engaged in a bona fide news purpose. Something along those lines. In other words, if you're going to say, hey, I've got your picture here, and if you pay me $200, that's not a bona fide news purpose. However, if a legitimate news source, a newspaper, TV station, something of that nature says they do it, but they don't condition on you paying them to take it off the website, that is bona fide. That's one way I think you could come at it and protect the legitimate news interests and legitimate public concerns versus what Mr. Strickland's trying to get to. I understand the problem, and it is a difficult. We worked on this bill last year trying to deal with that and protect, again, the legitimate media interest. And Atlanta is certainly in the state of Georgia, is a media center. And I think you've got to protect that. You've got to be very careful.
But is it, in terms of and your point about the ability to expand an investigation and the hypothetical, not really hypothetical at this point, it's a real example. But can't we get to that through law enforcement to law enforcement dissemination or publication or being able to share the photograph as opposed to being in the public domain?
Well,
I mean, your point went to investigation. It's very well taken. But don't we accomplish that by allowing
I don't know that you can. I don't know that you can, because if it's just law enforcement, they're not going to know who to talk to who may have seen this person in the jurisdiction. I think it's only when the public sees that and they say, hey, I did see this person around the time of this incident, this murder, and then they contact law enforcement and tell them that. If it's just law enforcement, they're not going to know that. They're not going to know that.
Yeah, but aren't they, in that scenario, isn't the individual, this individual in this particular scenario will be, telling some sort of story.
Right.
And at some point there's going to be communication between law enforcement of, look, here's the picture of this person, she says this, or does this fact pattern match anything that you may have encountered in a particular area. And there obviously, as you know as well as I do, there are the communication capability now nationally between law enforcement agencies is pretty good. It could always be better.
Yeah.
But it's pretty good, and the ability to communicate that image pretty quickly so that law enforcement gets it doesn't preclude their ability from an investigative standpoint to go out and question certain people or re-question certain people in an investigation. It's not as if they're, I guess the point is the motive then to go ahead and just take it, and if there is a similar fact pattern, a similar murder, let's say, 3 time zones away from here, is just to go ahead and smack it on the television and just see.
Well, you're going to reach so
see-
many more people as
see what
opposed to
sticks.
you're going to reach so many more people through a legitimate broadcast. Think about the nightly news, how many people that reaches, as opposed to a police officer trying to do the legwork, trying to contact these people, or putting out flyers, or whatever they're going to do. It's just you're just not going to reach the number of people.
No, I'm talking about where it goes to already in a pending investigation in some other area.
Yeah.
The image is, it's instantaneous, as we know.
Yeah.
It gets right to, then they're going to go to their witness list and say, did you happen to see something like that at that time?
But they may not have that witness, is what I'm saying. You're going to have witnesses come forward if they see that picture.
Right.
If they see that picture on the news or in the newspaper. The other point I want to make about Representative Strickland, his concern that if it's put on in the newspaper, then one of these websites that we're trying to deal with will take a picture of it and put it on their website. You're talking probably very, very few. I mean, you think about it. You don't see every day in the paper a picture of someone's mugshot or on the nightly news. You might see that once a week, once a month, a couple of times a month. That's it. I'm not real familiar with these websites, but what I've learned the last couple of years working on this legislation is most time they're not making their money off of the Lindsay Lohans of the world and their mugshots. They're making theirs off, Jane Smith and John Doe, and they take their pictures, who are never going to be in the newspaper, who are never going to be on the nightly news. So I don't think that frankly, allowing the legitimate news sources to print these pictures is going to be a lot of fodder for these websites, frankly. I don't think it is. They're going to do more of the nickel and dime stuff as opposed to, the celebrity or whatever you're talking about here. So I think if you let the legitimate news media publish these, you're not going to provide scores and scores of photographs for these websites that are just trying to shake people down, as I say.
Thank you. Mr. Pack.
Isn't Representative Strickland's intent to try to minimize the permanency, I guess, of these pictures on the internet, so that it's impairing them from being able to get jobs and things like that?
Mm-hmm.
I'm not so worried about the legitimate, like Turner's, Comcast, NBC, because I think it's very temporal and it's going to be gone.
Yep.
The problem is limiting your language, inserting your language about for commercial purposes. You would capture people like the Drudge Report. They post pictures up there, which I think most people will say they're a legitimate news aggregator, and they don't take money to take down the picture. They think
Right.
it's new. So I'm not quite sure if the approach that you're suggesting would actually get at the harm that Representative Strickland is trying to reach.
Well, if a photograph is up of someone who's been arrested and they've later been found to be not guilty, and they apply for a job, and the employer says, I see this mugshot, then I think you simply go to the local sheriff's department and you get the criminal history, and it shows where the case was dismissed or you were found not guilty, and say, here it is, I was found not guilty, here's my record.
I understand that.
Or my record's been expunged.
That's actually a very good point. My next question is, how do you guys get the electronic version? I think the sheriff's department, the PIOs email it to you guys, right?
I can't say for sure. I don't know. Well, we get them from the sheriff's department. How we actually get them, I couldn't tell you.
Seems to me the way to do it is to ban the sheriffs from emailing it or sending an electronic version. Because I look at it as, if you're saying ID is the issue, why can't you get the fingerprint cards?
Well,
or their social security numbers. Right, because there's other laws protecting that. So I'm not quite sure that there's additional protection you get because of electronic form of a booking photo versus something like fingerprints or private facts like social security numbers.
Well, a fingerprint shown on TV or in the newspaper is not going to help anybody identify anyone. Going back to the example I gave earlier, if they show this lady's fingerprints up in Pennsylvania, wherever it is, that's not going to help anybody reading the paper identify her or not identify her.
The other issue is, what if you take a picture in court of somebody in a jumpsuit, which is the same problem that I think you get to, Representative Strickland, because that's just as prejudicial as the booking shot, right?
This bill doesn't cover
Somebody
that.
with an orange jumpsuit would be, you say, wow, this guy was arrested.
This bill doesn't cover that. It
Right,
just says arrest booking photograph.
Right.
So if
But I would like to know how news agencies get electronic pictures of booking shots. Now, I bet the sheriff's department, or whoever they're arresting, they release it, and they may have a different understanding of
And
whether
this
or not
and this
they were-
bill would prohibit that unless and until they had been convicted. Yeah, and you know, again, it just gets down to a matter of policy, and should that be, you know, for legitimate news sources. Are you going to ban everyone just because a few are abusing it? Are you going to keep the legitimate ones from doing that? That's the policy you're really talking about here. You're going to wipe out the public's right to that information because you've got some offshore folks.
Well,
that are doing this.
that's my point, Mr. Edge. What level does the public have a right to know of a booking shot versus like a fingerprint? Are you saying because of the latentness of the fingerprint, it's not as the public has less access or less right to access that information versus a booking photo?
In terms of the public being able to identify, going back to Mr. Marsh's point, yes, sir. I think so. I mean, the fingerprint helps law enforcement. It doesn't help the general public. It's not newsworthy. The fingerprint, but the photograph is.
Would you agree with me that most news outlets, when they identify a suspect who's arrested, you put down how old they are, what city they live in, right?
Mm-hmm.
And so they're identifying factors.
Right.
But
without a picture, if they tell me this lady is 60 years old and lives in Scranton, Pennsylvania, unless I live up there, it doesn't tell me much. But if she supposedly committed a crime in Georgia, and I recognize the picture, that could be a big break for the law enforcement.
I'm going to call Mr. Coomer in just a second, but one reaction, one comment the vice chair made is, it's temporary and then it's gone. It's never gone.
Well, for if you look at AJC, for example,
never gone.
Well, I mean, they take it down and it's cached, and then you get recycled. So there's less chance of them finding that versus, like, for example, if you put Google, the algorithm says most frequent hits goes up top of the list.
Mm-hmm.
So unless you go down to 295th page after a week, you're not going to be able to find that photo. Although
somebody with an axe to grind,
right,
will find it.
So it looks like getting it from the supply side, tackling this problem from the supply side is probably better than trying to get it from the back end.
Well, again, do you want to totally ban something just because you've got some people that are misusing it? And the other point to Representative Kendrick's question, I think, again, someone could be successful on appeal, but that picture's out there under this bill, so the bill doesn't deal with that problem either.
We call Mr. Coomer.
Thank you, Mr. Chairman. Mr. Edge, in reviewing the bill, the current bill doesn't give any sort of protection from disclosure for these photos by independent action of the sheriff's office. For example, if the sheriff takes a photograph of me and he decides he wants my picture in the newspaper, even if this bill passes, he can hand it over to the editor and say, put this in the paper. There's no protection for me from that. And so really all we're doing in this bill, if I read it correctly, is removing the ability of individuals, corporations, news agencies, whomever, the public, from being able to get all of the booking photos, and instead telling law enforcement, you just decide which ones you want to put out there. Is that a fair reading of the bill?
I think you're correct, and I think the author acknowledged that a moment ago.
And so basically we're giving law enforcement agencies the discretion to pick and choose who they want to put under public scrutiny.
Yes, sir.
And then, we've talked about the whether there's a legitimate public interest. I don't buy the busted magazines, but I see them in the grocery store, at the gas station, and I guess pose the question: isn't the fact that those magazines are so popular, doesn't that show there is a public interest in this information? And the fact that we've been publishing these photos in newspapers for eons. And then I'll tell you too, from my own personal experience as a private practice attorney, I've got on the internet and done just a plain name search for people and found out information about them because these booking websites are out there, and that's a legitimate use of that information for me and for my clients. And
Representative Coomer, also, it just occurred to me, I guess this is still the law, under the state's DUI statutes, if you are if you are, I think what's your second offense, something like that, they have to publish your photo in the newspaper.
That's right.
Yeah.
And then one step further,
to inform the public.
Yeah. Well, and I think that's probably the best response I've heard so far is, there are people that we pass every day on the street, and we know we've seen them. I mean, in a small town like I live in, you see the same people. Yeah. I don't necessarily know everybody by name, but I would recognize that photograph, and that would give me some reason to remember. And maybe I would think, hey, I saw that guy over there behind the Piggly Wiggly hanging out, by the dumpster. Maybe that would be helpful information for law enforcement.
Right.
So I think there are problems with trying to pick and choose what's a legitimate purpose in this context. We're gonna hit that gnat with a sledgehammer, and it's going to do a lot more harm than we need.
And again, I understand exactly where the author's going with this, and we just, from our standpoint, just afraid it goes a little too far.
Calling Mr. Gravely, and then I want to hear, and we're going to hear from Ms. Andrade, I hope I'm saying that, with Reclaim Our Dignity, and then we'll discuss next steps. Mr. Gravely.
Thank you, Mr. Edge. And I get your point on that Pennsylvania news story.
Mm-hmm.
I would agree that's, I would want to know, and I think that's a very justifiable use. If somebody's confessed to a murder, and then there's 20 others, I think that individual's photo probably needs to be out there.
Mm-hmm.
And I've heard several times that the bill is too broad, the language is too broad. Are we talking about something here, and I'll let the author decide this, but I'm just trying to wrap my mind around it. If it was narrowed to say that this bill would apply to first offenders on non-violent crimes or whatnot, because if somebody's out there, they're posing a threat to society or whatnot,
mm-hmm.
I think the general public would have calls to find out who that individual may be or whatnot. To Mr. Coomer's question, that the public, I've got friends that have ended up, maybe even some family members that are in the Busted magazine currently. And the reason they're so popular is because they go and they buy every one of them so nobody else sees them in our local community. And that's a fact. But I was just wondering if indeed narrowing that to, somebody's in a college kid in Buckhead gets arrested or booked in for public drunkenness or whatnot.
Right.
Yeah, they weren't doing anything, but yet that could be a hindrance to some type of job or whatnot. But yeah, if you've got a violent offender out there, you've got somebody that is a menace to society, the public may very well have a need to know those.
Yes.
So that's just my question. I don't know if the author would agree, or if the authors could consider that, maybe narrowing the focus. Thank you, Mr. Chairman.
Thank you, Mr. Edge.
Thank you,
Appreciate
Mr. Chairman.
Let's hear from Ms. Sophia Andrade. Am I saying that correctly? Andrade. Not even close. Thank you. Sorry. With Reclaim Our Dignity, welcome.
Thank you.
If you could confine your comments to a few minutes, we'd appreciate it.
Okay.
Thank you.
Well, I'll just say last year I actually brought this issue to Representative Bruce, and thus started Reclaim Our Dignity, because I figured if I'm in a situation, I'm sure that many other people are in the situation. I am very much in support of this bill because it is steps to the big picture. Really, the bill that passed last year is actually not as effective as we would have liked it to have been, because all these companies that are overseas, when you get in touch with them, they have no jurisdiction here. They don't apply to our laws. So they laugh at HB 150. And I'm actually not representing myself. I'm representing over 75 victims that have reached out to me. It's preventing people's lives from moving on. My picture, I was arrested for 1 day on a lie. And I got 3 weeks before court, the case was thrown out. What public interest does my photograph have? I will never pay them a penny. And it's been 4 years. I am still on the website. And we need this law. We need something. We need federal laws. We need this law to protect so many people that are hurting. People are dying. People have committed suicide because of these things because they can't handle it. And we're not talking about hardened criminal. We're talking about people who, just like Representative Gravely just said, people just been arrested for little minor infractions, and your photograph is out there forever, and you can't move on because it's over 80 of these companies that I know of, the last count, that are out there. I'm not talking about the news media. We're not talking about that. We're talking about these websites that has no other reason but to charge you money. There are 9 states here, and I think there are actually 10 that I have, but you have Kansas, Louisiana, New Jersey, Texas. These states are making a statement, trying to know that these companies are that they are out to extort people, and this is all that we're fighting. We're just fighting for our lives back. And you know, even if somebody committed a little crime, whatever it is, I didn't commit a crime, and I'm still out there. But if you commit a little crime, should you hold that person for the rest of their life on a website? And I know the stigmatism from this. I'm telling you, I have not worked in a full-time job in 3 years, and I've heard the stories about trying to get jobs. And I heard his statement, "Oh, just show your expunge." I went through the expungement. Just show those things. No, every employer are Googling you now, and if you've been arrested, they don't want to even know why you're arrested. They don't want to deal with it. They don't want you. And I'll just finish up because sometimes I get very emotional over this stuff here.
I don't blame you.
Yes, because
we really don't. So
it has ruined my life.
Don't worry
and
about it.
I'm sure it's ruining so many other people's life. And I'll be here every time, and I'll get through this. But Kansas, mugshots are criminal investigation records, and public disclosure is not required. You have Louisiana, mugshots are not public until a final judgment and conviction or acceptance of a plea of guilt. And that's all we're asking for. Don't put my photograph out there unless I'm guilty of some crime. I'm not guilty of a crime, and I still exist today. And I thank you for your time, and I really hope that you consider this bill. Thank you.
We will, and we thank you for taking the time to share your story. We've heard stories like that, similar stories, so you're certainly not alone. And it is a balance. This issue calls for a balance. And that's what we're going to attempt to do. I'm going to ask the author, we'll probably take the opportunity to step back, see what kind of balance we can strike on this. I mean, you hear stories like that all the time. Boyfriend, girlfriend, he said, she said, all of a sudden somebody's getting picked up, and you can't put that toothpaste back in the tube. But we also hear the good points that were made by what I'll call the mainstream media, however you care to define that. And they're, you know, and those are points, right? It really is an eye of the beholder determination, isn't it? Subjective all the way. That's okay. But that's, you know, that's the balance that we have to go ahead and attempt to strike. So let's take the time that we have, which is not a lot of time, but let's go ahead and take the time that we have, step back and see if we can accomplish that. We're going to have a full committee meeting tomorrow afternoon. It'll be upon adjournment. As of this minute, it will be on 2 bills. You have a notice in your inbox right now that will be hearing only, just FYI. If Mr. Strickland is able to go ahead and balance those scales between then and now, then we'll add that bill to the agenda. If not, then it would be at the next full committee whenever we have that. And those will be on, tomorrow will be House Bill 8, it's in your notice, but House Bill 863 and House Bill 965, but again, those will be hearing only. What you're seeing, members of the committee, is that now that we're getting into the time crunch on day 30, we're taking the full committee and using it as subcommittee where we can, where it may be appropriate. There are still bills going into subcommittee, but we're trying to work on parallel tracks. So thank you to council for hard work, and we're adjourned.